So you just received a notice in the mail saying that you must appear. Do you actually have to appear if you have an attorney? In this video, we'll answer that question. Now, if you've ever gone to court, maybe for your own case, or maybe just watching court or going with somebody else, it's quite possible you might frequently hear certain attorneys saying that they're appearing for somebody pursuant to 977, or they'll say it's a 977 appearance. It's quite likely you might hear those three numbers barked out quite frequently. Well, what does that mean? California Penal Code Section 977 allows an attorney to appear on behalf of a defendant in certain criminal cases. What this means basically is, in some situations, even though you have a criminal case pending against you in California, you might not actually have to appear in court if your attorney simply appears for you on your behalf. California Penal Code Section 977 applies to both misdemeanors and felony cases, but it applies most easily to misdemeanor cases. In misdemeanor cases, according to California Penal Code 977, a defendant in a criminal case may appear in court through their attorney. There are two noteworthy exceptions. One, in domestic violence cases, the defendant has to be present at the time of the initial appearance, at the time of a change of plea, during progress reports. The statute specifically orders the defendant to appear in person on those dates. California Penal Code Section 977 also says that the judge has the authority to order a defendant present in a particular case when dealing with charges involving driving under the influence. Sometimes this subsection comes up and people, I think, misinterpret it to read that 977 doesn't apply to DUI cases at all. That's not the right way to read it. 977 does allow for appearance through your attorney in DUI cases. It's just that the judge does reserve some power in their discretion to order the defendant present anyway. I guess the point that I'm trying to make here is you should definitely speak with your attorney and confirm, hey, do you think I really need to appear, or are you allowed to appear on my behalf? Now, what about felony cases? Is it okay to have your attorney just go to court for you as well? Well, yes, and actually in some cases, even before the pandemic, California law recognized the ability to appear through your attorney only in felony cases. However, the rules are much more strict. California Penal Code Section 977 still requires the defendant to appear in person at their first court date, at the time of arraignment, or whenever they enter a change of plea in a felony case, and at the preliminary hearing and at trial. For other intervening court dates like pretrial conferences or what have you, the defendant also has to make an appearance themselves unless they've actually signed and executed a waiver of their personal presence at court. And that waiver has to be filed with the court, and a record has to be made about the defendant making their waiver of the right to be personally present before the court can accept it. The easiest way to do this is for the defendant to simply sign the waiver of personal presence in open court at an earlier court date, and then the ability to have their attorney appear for them through Penal Code Section 977 can sometimes carry over in that circumstance. Again, the philosophy is similar to misdemeanor cases. With the right steps being taken and the right kind of case, a defendant can appear in court through their attorney. It's important to know that you must still have good contact with your attorney. Your attorney can't actually appear on your behalf if they don't have good contact with you. I must say, I've had some kind of weird cases occasionally where my client simply assumes they go on a trip, whether it's for a family emergency or maybe just for a vacation. They go on a trip out of the country without notifying their attorney. And they do this because they assume that if they're going out of the country, then they're just going to get a warrant and there's nothing they can do about it. And then I've had to tell that client, if only we stayed in contact, I could have just made the appearance for you. You could have been on the move for all I care. But, because you didn't make the effort to stay in contact with me, I didn't know where you were. I didn't have the authority. Point is here, stay in touch with your attorney. Confirm with them whether they think your physical presence in court is actually needed. The rules are different for different types of felony and misdemeanor cases, but a lot of times you are able to make that appearance through your attorney, and that can make your life a lot easier during the difficult time of fighting a criminal case. I hope this is helpful. Thanks, and stay safe out there.